My name is Kilcommins. I'm a professor of law in the School of Law at the University of Limerick, and one of my central research interests is victims in the Irish criminal process. The status of the victim has changed dramatically over the years. They've moved from a central to a peripheral position, and now they're beginning to re-emerge again as an important stakeholder in the Irish criminal process. So in the 17th and 18th century, the victim was principal investigator and key decision maker in the criminal process. They could decide not to invoke the law and let the criminal go free. They could engage the civil process and sue the offender. They could then elect to invoke the criminal law, but they could set the charge and decide what the penalty would be. And so ordinarily, cases never even came before the criminal courts. They were usually settled out of court. If a criminal case did go ahead, it was the victim's energy that drove it. The victim would gather the evidence, they would gather witnesses, they would engage in fact-finding, they would present the evidence in court, and they would bear the costs involved. And it was a personal altercation in the court between the accused and the victim. They would both be in court together. The victim would tell his or her side of the story, and at the end of the victim's testimony, all the focus would turn to the accused, and the accused was required to speak. So they were referred to as accused speaks trials. And then gradually in the 19th century, that whole process changed, and the state began to colonise ownership of the conflict. And it really actually, Ireland is interesting because it was one of the first countries in the world which was being used as a kind of a social laboratory by Britain to test this new model. And so to begin with, you had a centralised police force commencing in Dublin in 1786, and they began to gather the evidence themselves. So no longer requiring victims who they believed could be capricious, who could engage in an arbitrary manner, sometimes could be overly vengeful. And so the police, the centralised police, began to investigate. And then that was followed very, very quickly by a centralised prosecution system, beginning again in Dublin in 1801. Now solicitors were beginning to prosecute on behalf of the Crown. And so this changed the entire dynamic. And what ended up happening was it became a state versus accused dyad. And this really emphasised then an equality of arms framework, because no longer were the victim and the accused meeting at the same level. Now it was the state versus the accused, and the accused required a whole series of rights and safeguards to ensure some sort of parity between both parties. And one of the first things that happened was lawyers were now allowed to represent the accused. And the first thing lawyers did when they represented the accused was shut the accused up. And so it was no longer an accused speaks trial. And what did this mean for the victim? This new model transcended the victim's interaction with the criminal process and how it was presented and legitimated. And so the victim found themselves, from being a cornerstone in the regulation of the conflict, they now found themselves, and their individual experiences, which was so important under the old model, now these individual experiences were subsumed within the public interest. And their conflict was prosecuted on behalf of the state. And so what this meant for them really, that they were confined to a bit-part role, possibly a prosecution witness if needed at all. And that became the model then, and to some extent remains the model today. But from the 1970s onwards, we began to see a gradual re-emergence of the victim. And there are a number of reasons why this happened. The first one, we see the emergence of victimology as a discipline. And up to that point, it was all about criminology. Who is the offender? Why did the offender commit the crime? Was there a psychological dimension? Was it because a lack of social capital? Was it because a lack of controls in their lives? Was it because of labelling or whatever? Post-Second World War, we begin to see who is the victim? Why are they a victim? Are they re-victimised? Are they reporting crime? And this began to emerge. And that was followed up then by what we call mass victimisation surveys. They first began in the US in the 1970s, then in England and Wales in the 1980s, and in Ireland we began to see mass victimisation surveys. And they began to reveal new information, issues such as the under-reporting of crime, attrition rates, repeat victimisation and so on. So these were bringing new issues to the fore in the criminal justice system that previously weren't known. On top of that then you can mention the women's movement, which was really important in kind of bringing a focus to bear on the types of crimes that were occurring in people's lives and the type of issues that were not being reported. And so you see, for example, the first women's domestic shelter being introduced in Dublin in 1974, impetus largely coming from the women's movement, and the first rape crisis centre being set up in Dublin in 1977. So this also helped bring victims to the fore. And that then was followed up, I think, by rising crime rates. And so there was a feeling for most of the 20th century that we could win the war on crime. But from about the 1970s onwards, it was seen that Western countries were high crime societies, and this wasn't going to change. And so if you look at Ireland, we moved from, in the 1960s, 7,500 indictable crimes per year, to by 1970, 15,000, and by 1981 then it had moved to about 89,000. So we began to live in a high crime society, and so it was obvious then that the focus was going to change in terms of what we saw as important in the criminal process. And added to that then there was a European dimension. The Council of Europe, the United Nations, the European Union began to champion the rights of victims a lot more, and even the European Court of Human Rights began to, although there is no specific right for victims of crime in the European Convention of Human Rights, began around the periphery, around various different rights, to interpret them in ways that supported victims of crime. And I suppose the last issue that was important, particularly for Ireland, was that from about the mid-1990s onwards, actually from about 1993 onwards, you began to see, when these scandals around church and institutional abuses began to come to the fore, it became very much part of the Irish zeitgeist, and what was revealing for the country as a whole was, the illegitimate and abusive hierarchies of power and the impact that this had on ordinary citizens. So all of this was coming to the fore, and it was beginning to put victims on the agenda. And so we've seen since then, we've seen the law increasingly beginning to recognise victims of crime through a whole variety of piecemeal provisions relating to marital rape, for example, as one. In 1990, for the first time, it was recognised that a husband could not rape his wife inside marriage. Now, there's still problems with that. There's only been 3 prosecutions to date, but at least it's putting it on the agenda. And again, I suppose largely as a result of the women's movement bringing this to the fore. And then other provisions such as the introduction of victim impact statements and so on, allowing victims to tell their story at least at sentencing stage. And you see compensation orders being introduced in 1994 and so on. So a whole series of piecemeal provisions being introduced. And that's recently culminated in the introduction of a new European directive relating to victims of crime. This is transforming how victims interact with the criminal process. Now, there are still lots of problems. And they include particularly underreporting. It's estimated that 1 in 4 people don't report crimes. And that can be even higher in respect of issues such as sexual abuse or domestic violence. So for example, in a study in 2013, it's estimated that 1 in 3 Irish women are subjected to psychological abuse by their partners. And it's estimated that 1 in 6 Irish women are subjected to physical abuse. Well, those figures are really, really high. And they have to be grappled with in the coming years, but at least now there's an increased awareness about those types of issues. And again, there's also, even when we get to court, the attrition rates are high, so how many prosecutions are successful? And again, in a study in 2009 revealed that of 100 rape cases that were being mapped, only 8 of those actually resulted in a conviction. So you can see, even when cases are getting before the courts, they're still very, very hard to prove. And those statistics are even higher in respect of persons with intellectual disabilities. So the attrition rates remain quite high. So there's still lots of problems, but it's clear that victims and victims' rights are much more on the agenda today than they were previously. And so if you want to know more about these types of issues, either through doctrinal law, such as criminal law or evidence law or criminal procedure, or you're more interested in it at a theoretical level in terms of penology and victimology, then you can come to the University of Limerick and the School of Law to learn more about these types of issues.